The reenactments and commentary in this program may contain frank talk of a sexual nature. Viewer discretion is advised.
Can the king of pop beat it, or will jurors decide that Michael Jackson is just bad? Really, really bad. 13 weeks of testimony, folks, 140 witnesses, and it could all come down to this. Closing arguments, the final showdown. Hello, I'm James Curtis. Welcome to E's coverage of the Michael Jackson trial. Jackson blew a kiss to fans before entering the Santa Maria courthouse on what could be one of his last days as a free man. Prosecutors argue the superstar is a predator. Team Jackson, on the other hand, maintains he's actually the prey. As closing arguments got underway, the state went first as provided by law. District Attorney Tom Sneddon, however, stepped aside and left it all up to prosecutor Ron Zonen to make the case. Here's how the jurors heard it according to the courtroom transcripts.
Now, I'd like to read something to you, and this is something that you heard in the course of this trial. I'm not going to tell you right now when you heard it or who spoke it, but you might recognize it. And at the conclusion, I will tell you where it came from. I want to take it a step further, and I want to let all of you know that I think an opening statement is a contract. You make promises in an opening statement. You better fulfill them. Because at the end of the trial, the jury's going to know whether you did or you didn't. And I say to you right now, I'm going to make some promises in this case. I am going to fulfill them, and I want you to judge me accordingly at the end. Do you remember who spoke those words? That was Thomas Mesereau at the very beginning of his opening statement. He was making a contract with you, a contract that what he was representing in the course of his opening statement, he was going to prove. And he was inviting you to judge him on whether or not he did so. Let's begin that judgment.
That obviously ties into that idea of the defense having the burden. I'm sorry, that's wrong. But next, did the defense deliver, nonetheless, the goods?
Mr. Mesereau either knew or should have known that what he said was simply not true. Janet approached Mike Tyson, Adam Sandler, and Jim Carrey for money. Did you see any of those three come in here? I didn't. And I know what they all look like, and I think probably most of you know what most of the three of them look like. And I suspect you would have recognized them as well. There was some testimony that one of them, I believe Jim Carrey, or Adam Sandler, I think it was, gave a gift to Gavin. There's absolutely no evidence that Janet ever met any of the three of them. There's no evidence she ever asked any of the three of them for anything. There's no evidence she ever received anything from the three of them. Janet tried to shake down Jay Leno. Jay Leno testified it couldn't be further from the truth.
All right, a good start for the prosecutor, but we got to back up before we get into nuts and bolts. No Tom Sneddon.
Mistake, in my opinion. I think it's almost like a concession. I think the jury has to wonder why Tom Sneddon didn't get involved in this argument. He's the DA of that county. He's the lead prosecutor. And if I was a juror, I would have some question about that.
I would not have any question about that, because although Tom Sneddon is the DA in the county, Ron Zonen has had the bulk of the difficult witnesses. Ron Zonen has been the person out front in front of this jury. I think it was a natural choice for Mr. Zonen to do the closing.
Still, I think the jurors have to wonder what this means. Does it signal something that Mr. Sneddon is not doing the closing argument?
But let's not forget, prosecutors under California law get two opportunities to argue: an opening argument, a closing argument. It's a sandwich. Defense in the middle. Maybe we'll see him at the end.
No, it's Zonen all the way.
Let's get into the substance, and we'll see if that bears true. With respect to the opening statement, reading a technique that I'm sure we've all used, getting the opposition's opening statement and making them live with it.
And that's the difficulty and the problem, really, some would say, with the defense making an opening at all. Because what it does is it causes the jurors to think that you as the defense have the burden of proof, which of course you do not. And it allows Mr. Zonen to do exactly what he did, go in, zero in on the things that Mr. Mesereau said he would do and didn't do.
Look, Mesereau's not on trial here, or he'd probably be convicted because he didn't prove what he said he was going to prove.
Yes, he did.
And Ricky raised that very early on. That's a tactic you got to be very careful of.
All right, as we continue, prosecutor Ron Zonen continues with his closing argument. How will he deal with the defense's favorite target? You know it well, the accuser's mother.
Did she make a false representation on an application with the Department of Social Services for Welfare? Yes, she did. Yes, she did. She got a check for $32,000. A check for $32,000. From the disposition of that settlement, that check was received and cashed on November 5th, 01. The settlement was resolved on the 18th of October, 01. 15 days later, she went on welfare, and she did not disclose that she had $32,000 from that. This is a woman who was on her own with 3 children. That was a mistake. It was fraud. She shouldn't have done it. And she stood before you at age 37 by the time that she was here as a witness in this case, and that is the only thing in her lifetime that she has done that she clearly should not have done. That was a bad mistake on her part, and she may yet have to deal with the consequences before all this is over.
As I recall it, she stood before them and took the fifth, but that's another issue. Next, what made Janet become desperate to get her family out of Neverland?
From the moment that Janet understood that Michael Jackson posed a threat to her child, and this was not molestation, that wasn't what she was thinking. It was alcohol being furnished to a child who was sick and still undergoing medical attention. From the moment she learned that, 36 hours later, her children were out of Neverland and never went back. 36 hours.
So much for, at least according to this version of the facts, the how many times did you escape theory offered by the defense, no?
Well, yes and no. I think that this is Zonen's high point. I think it's a point that most people have really not thought about. The way he tells this story is as follows, that this mother found out by virtue of her son having to have a urine test that he had been drinking alcohol at Neverland, and she scoops those children and takes them out of her. If that gets rid of the conspiracy to falsely imprison, so be it. But what it does is it sets her apart from all the other mothers who let their kids stay and stay
Does it
and
really?
stay.
Yeah, but Mr. Zonen, I think, goes too far when he says the only thing in her lifetime that she did wrong was the fraud.
Yeah.
I mean, that's going too far. Of course, he has to acknowledge the fraud. That was the right thing to do. But to go that far, that's the only thing she's done wrong. Come on. The jurors know that's not right.
That's right, and it's worse than that. When he makes a statement like that, he vouches for her credibility. He doesn't need to do that, didn't need to do that in his
And now
argument.
he stepped out there. Will it come back to bite him in the form of an adverse prosecution verdict? When we return, the prosecution paints a portentous picture of Neverland. We'll tell you what that means, too. And what does defense attorney Tom Mesereau really think about the accuser's family? Stay with us.
The reenactments and commentary in this program may contain frank talk of a sexual nature. Viewer discretion is advised.
Welcome back. The prosecution argues that Michael Jackson groomed and seduced young boys for sex with lavish gifts and free-for-alls at Neverland and some shopping sprees, too. But how did he pick his young prey? Here's what Prosecutor Ron Zonen told jurors according to the courtroom transcripts.
And at night, they entered into the world of the forbidden. At night, they went into Michael Jackson's room, which is a veritable fortress. It is a room that nobody else has access to. It is a room that has codes and locks and multiple doors and alarm systems. And they knew all of those alarm systems and all of those codes, and they stayed there. And they knew all of that information because Michael Jackson wanted them to know all of that information. And inside that room, in the evening time, they entered the world of the forbidden, and they learned about human sexuality from somebody who was only too willing to be their teacher. So, what happened over that particular period of time? Well, the vulnerable child is the one who simply doesn't have the protection. A colleague of mine uses the expression, he says, the lion on the Serengeti doesn't go after the strongest antelope. The lion on the Serengeti goes after the weakest antelope. All predators go after the weakest, not the strongest. To distinguish the weakest in terms of children is the level of protection their parents are able or unable to afford. And in this case, this was the vulnerable child.
That was good. Now, what does the prosecution think jurors should learn from that 2003 police videotaped interview with the accuser?
The suggestion that this child should subject himself to the humiliation of this kind of an ordeal and the ordeal of going through that interview with Steve Rubell that you watched, and you watched that twisted response of a small child having to disclose for the first time those kinds of words at age 13, the suggestion that all of this was planned and plotted and it was simply nothing more than a shakedown, a good acting job, is nonsense. It's unmitigated rubbish. You cannot do that to a child. It would be impossible to do, even if he was motivated to do it. And he wasn't. And he wasn't. The incentive in this case by Michael Jackson and all of his employees was, first of all, to exploit this family financially so that he might be able to salvage a second career financially and bring some much-needed funds into that business enterprise. And secondly, to salvage his career. And that was done at the expense of this family. It is also the case that Gavin, demonstrating remarkable courage in coming into this courtroom, gave testimony to you about a series of events that took place in Michael Jackson's bedroom when Michael Jackson, not for the first time, took sexual liberties with a 13-year-old boy. That information and testimony is entirely credible, entirely accurate, and entirely truthful. It should be believed, and Michael Jackson should be held responsible for what he did.
Howard Weitzman doing a pretty good job, isn't he?
I think it was a real good job. He finally got to where he should have been, and he pushed the emotional buttons with this jury, and that's what you have to do to win in a case like this. And by the way, this argument, in my opinion, was very, very persuasive.
And one of the things that we didn't see is that he put up the photos of the boys, the 1108 boys and this boy, and they bear a striking resemblance to one another, and that seemed to be very powerful as well.
One of the things that he does so well in what we have just watched is that he goes not only toward the heart and the gut, but he also goes to the head, because he's not only dealing with the emotion of carrying through what he wants that jury to get to, but it's words of like entered the world of the forbidden, and they learned about human sexuality from somebody who is only too willing to be their teacher. The whole image also goes, well, it's powerful, and it goes to the jurors' common sense.
Absolutely. But what about the so-called 1108s, prior bad act kids who came and testified for the defense? Does it sufficiently deal with it?
Well, he didn't deal with it.
Yeah, but and Mesereau will deal with it, and then we'll see whether Zonin handles it in his rebuttal.
Exactly,
Sure,
but does it look like at this juncture that the prosecution is avoiding something that's damaging to them? That's never a good idea, folks, I can tell you from experience. Next, defense attorney Tom Mesereau gets his chance to speak directly to the jury, he pulls no punches concerning his opinion of the accuser's family.
Now, ladies and gentlemen, the issue is very, very simple. If you do not believe the beyond a reasonable doubt, Michael Jackson must be acquitted. That's the law. And these claims are completely based upon your having to believe the every which way but Sunday. You've got to believe them. Now, I submit that the witnesses we have called and the cross-examination we have elicited in this case proves the are con artists, actors, and liars. And I submit you cannot let injustice happen in this courtroom. You cannot let these people prevail. They're all just ready to pounce with a conviction. I don't have to say much about welfare fraud and perjury. We proved it. The applications proved it. They're all signed under penalty of perjury. They're all manipulative. Not only what's said and what's not said, but what she does. She takes her welfare checks and puts them through Jay Jackson's account, a person in the United States Army making $80,000 a year. She doesn't want a record of where she's depositing them. She doesn't want them to be traced. She lies about settlement. She lies about where she's living. She lies about who's helping support her. She lies to get food stamps. She lies to get disability. Everything she can get her hands on, we have proven, is true. And perjury is meaningless to her. She lied in the J.C. Penney depositions. She lied on the applications. Perjury is a habit, and she committed perjury right in this courtroom.
Yeah, but what about the molestation? As defense attorney Tom Mesereau continues, he questions the prosecution's ever-elusive timeline.
This is a case of prosecution based on the lies and innuendo and exaggerations only. Do any of you really think, from what you've learned about Mr. Jackson, that he would even be capable of running a conspiracy to abduct children, falsely imprison a family, ship them off to Brazil? For what purpose? To make a documentary that they didn't even appear in? For what purpose? I want you to think carefully, ladies and gentlemen. I beg you to think carefully about the dates of the alleged molestation. The charge says the molestations occurred February 20th, 2003 through March 12th, 2003. They claim the molestations begin right after the filming of the rebuttal and the DCFS interview. According to the prosecution, this criminal conspiracy is beginning on February 1st, 19 days before the alleged molestation. Put all this together. What does it say to you about the dates the so-called molestation occurred? It's absurd. It's unrealistic, and it makes no sense, because the whole case makes no sense.
Is that the strongest arguments, and did he make it really well?
James Curtis has always said that's one of the strongest arguments. The timeline.
He's got to be right there.
And it is.
Yeah, indeed it is. And in deference to Sean, I can't help it. It makes no sense. It makes no sense. It doesn't fit. If it doesn't fit, you must acquit. He didn't have to say it, because I will bet the house that jurors in the box are saying it for him. This is his strong suit. This is where he should be. And it's the only sad thing about this is he didn't get to start there in the courtroom itself.
What's so amazing about closing argument, as we're seeing and as the courtroom observers have said, when you were listening to Mr. Zonin, you were there ready to convict. Now, listening to Mr. Mesereau, you're ready to acquit. And of course, the prosecutor gets the last word.
It is what trials are all about.
It is. But, guys, come on. We should have, and I mean we in the larger sense of the community, everybody listening to this trial and following it, should have been right where you just described, when the prosecution is in its case in chief, ready to convict, when the defense is in its case in chief, ready to acquit.
But we
weren't
there.
We
weren't there because Michael Jackson has admitted he takes young boys, invites them into his bedroom, and allows them to sleep with him, and that in and of itself causes a whole negative picture to be painted of Michael, and people want to believe, honestly, people want to believe that somebody that does that must be doing something wrong, even if it's not true.
That's true, but what about the quality of the prosecution's case? Where was that, oh, he must be guilty, when the evidence was being presented, when we returned? What image of the accuser does the defense hope to paint in the mind's eye of each juror? Stay with us.
The reenactments and commentary in this program may contain frank talk of a sexual nature. Viewer discretion is advised.
Welcome back. As defense attorney Tom Mesereau continues with his closing argument, he gives the jurors a visual image of the accuser based on a point that Mesereau considers to be pivotal in this trial. Here's what happened according to the courtroom transcripts.
This is a family where children have been taught to con, and children have been taught to lie, and children have been taught to very brashly and brazenly and with no embarrassment of any type of restraint call one celebrity after another and keep bombarding them with calls like they did to Jay Leno, like they did to Chris Tucker, like they did to Michael Jackson. This is the way they've been taught. You know, one of the most important moments in this trial was, I submit, that when you get in the jury room, discuss this occurrence. He's on the witness stand. He describes the alleged sexual touching, the alleged molestation. You saw no emotion whatsoever. When did you see him really get mad? When he talked about Michael Jackson abandoning his family. Do you remember? Do you remember the emotion, the anger? Do you remember how he reacted? You can't look at a transcript and see it. You have to see it in person. He was angry because he felt that Michael Jackson had abandoned his family. They were not part of his world, and he wanted to be part of his world. That was clear.
Not only angry when he testified during that portion, I think that's accurate, but in that so-called rebuttal video that I had the opportunity to see while at the courthouse, he looked quite content and happy to be talking praisingly about Michael Jackson.
You're talking about the rebuttal documentary.
Yes, the one that was constructed by the Jackson team.
But he's talking about that last tape that was shown, and I guess this explains why he chose not to put any witness on. He thought the tape spoke for itself and that it was helpful to the defense.
Well, the judge said, look, you could only consider it for demeanor, whatever that means. So he couldn't go in and rebut it with the content and say he was lying. He was kind of stuck.
But he thinks the demeanor is helpful to the defense, apparently.
That's interesting. I want to say one other thing. I think Ron Zonen could have set Mesereau up by not addressing the 1108 issues. That is, the other boys that came in or were allegedly molested. And I think he's laying back to see if Mesereau touches on it in his closing argument.
Which, of course, he has to.
Correct. About 10 seconds, Ricky. Go ahead.
I just think that really what happens here is we see Mr. Mesereau looking at, quote-unquote, the actor in the accuser and pointing to the different ways that the jury has seen him. And the jury has got to think about that hard.
And is the mom the choreographer and script writer? What a dramatic week as the trial comes to a close, folks. Be sure to watch our exclusive coverage of the Michael Jackson trial, the weekend wrap-up show, Saturday, 10 a.m. and 4 p.m. And you can watch me every day on E! News with the latest from the jury. And when the verdict comes in, we're going to all get back together. We'll bring it to you live right here on E! Last chance.